And on the Zoom call there, it says, it's going to read the trustee of the person, Mohammed Idris. Could you come on the Zoom call?
Can you hear me?
I can. Can you activate your camera?
Yes, just give me a second.
Hi there. So are you, is it Mohammed Idris?
The trustee. I'm the trustee. The trustee of the person is here, and all the beneficiaries have been already named.
Okay, so I'm looking for Mohammed Idris. If you're not him, you're free to go. We'll issue a warrant for him. Okay, I'm not sure what that means. You're going to have to explain that to me. I mean, I know what a trustee is. When they have a trustee over as a person, that's someone who governs their affairs if they're not able to manage their own. Generally, people aren't trustees for themselves. And so that's why, and if you're, I'm not sure exactly what that means. And you're going to have to explain that to me.
What I mean,
like
by
I say,
the
if you're, I'm sorry.
What I'm saying is the trustee of the person is here, and all the beneficiaries are already been named. And it's on a trust, and that trust is private.
Okay, do you have a name?
Because you are claiming that you are the trustee, or the prosecutor is claiming to be the trustee, and the investors
I'm not.
to be the beneficiaries.
Okay, I'm going to stop you there for a second, because I'm not claiming that. No, you can't finish. When you say you are claiming to be something that I'm not doing, no, I'm not going to say that, because that's not true. I'm not claiming to be anything other than the judge in Thurston County District Court who's on this calendar. So I'm not the trustee of anybody.
Well, you're
all right. This case goes sideways immediately. From the very first exchange, you can tell this isn't about facts or evidence. It's about a belief system. The defendant isn't responding to the court as a legal forum. He's responding to it like it's a philosophical debate about identity and trust law. And that gap is going to cost him.
Here to come after my personal trust, correct?
No. Why would you think that?
I object being a trustor.
Okay, well, you're not one. I'm just trying to find out who you are.
I can't get any clearer when I said the trustee of the person is here.
Okay, is the person here? You're not going to answer that.
The trustee of the person is here.
Okay.
And the beneficiaries have already been named. Is on a trust, and it's private, and my trust is private.
What's the state's position on where this case is headed? And then I can come back and speak with
Your Honor,
who I assume the trustee of the person is the person named as Mohammed Idris. And so, but let me hear from you what the state's position, these cases look like there's a fraction of failure to control a traffic device. There's a special fuel trip permit. And then there's a failure to comply charge.
Yes.
So what's the state's position on where we're going from here?
If Mohammed Idris is not present, the state would ask for a warrant.
Mohammed Idris I'm going to consider him present based on his verbiage. I know he's operating.
This is the moment that really matters. The judge lays out the reality: misdemeanor charges, possible jail time, real consequences. None of this is symbolic. None of it is theoretical. And yet, the defendant is still speaking as if words alone can erase jurisdiction.
We are with this, and then we'll go from there. So, you said a lot of things already that just simply are not correct. And here's where you're at right now. All right. And so you've been charged. There's three things at issue here. There's two statutes that are alleged to have been violated: violation of a special fuel trip permit, violation of vehicle operator refusing to comply with an officer. And those are both, I think, simple misdemeanors, which carry with them maximum penalties of 90 days in jail and a $1,000 fine. Pleas of not guilty have been entered. And then these cases, they're both criminal cases. And what happens is they either resolve through some sort of plea or some sort of agreement, or they proceed to a jury trial. And now, if you go to it, since they are criminal cases.
Watch what's happening here. The judge asks a simple yes or no question about legal representation, and the defendant cannot answer it. Not because he doesn't hear it, but because answering it would mean acknowledging the court's authority. And that refusal becomes the trap.
I can screen you for court-appointed counsel, or you can hire an attorney to represent yourself.
Do I have a standing to speak?
Yes.
Okay, I object to what the prosecutor has said.
Okay.
And I'm standing on, I am.
You're standing on what?
The trustee of the person is here, and the beneficiaries have already been named.
Okay.
It's not a trust and it's private.
Okay.
And I object to the prosecutor saying that representing myself, I object to that. I object to being the trustor. And I'm not here to give out gifts, reducing the public law or the public debt. Because I'm brought in as a trustor to give out gifts, and turn around, and what the court is doing is coming after me for the commercial promise. So for that reason, I am the trustee. I'm standing on that position.
All right.
And I'm not here to...
This explanation from the judge is devastatingly simple. If naming yourself a trustee worked, no one would ever be convicted of anything. This isn't sarcasm, it's logic. And you can hear the frustration creeping in, because the judge knows the defendant is walking himself toward disaster.
Been named to me, so I don't know who they are, and they're really not interested. I mean, if life were that easy, anybody could do that in any criminal charge. Anybody get charged with anything? Well, I'll just name myself the trustee of the person and name some beneficiaries, then you're off the hook. You know, things just don't work that way.
How come they don't do it?
And so in terms of, you know, at some point on the, there was a scene where you were contacted by a law enforcement officer, or maybe even more than one. They identified some charges or some statutes you were not complying with, including, you know, the special field trip permit, and you refused to comply with the officers and things of that sort. So they refer that to the prosecutor's office. They're charging a crime. And I've told you what those two, again, these cases either resolve, and if you've been on the Zoom call, which I think you have for a while, you've seen some of these cases resolve, or they go for a jury trial. And again, you've seen all these other attorneys who represent these folks. I mean, if they could make these cases go away simply by naming someone as a trustee or naming the charged person as a trustee, I mean, shoot, they'd all do it. And then nobody could ever be prosecuted for anything. So that's why I'm wondering why you think that. And now I'm losing my voice.
This is the warning moment. The judge isn't threatening, he's advising. He's saying, you are about to face a trained prosecutor, rules of evidence, and a jury alone. This is the last off-ramp, and the defendant doesn't even look at it.
Talked about, you also have the right to go to trial and call witnesses and so forth. And so just let me finish, please. Don't interrupt me. I know what you're about to say, but I'm going to talk for a while here. So just please don't interrupt me. And at the end of it, then you can say what you're going to say. All right.
My apologies.
So this case has started. This case is headed towards trial, apparently. And if my voice holds out, the trial is going to take place someday before October 15th. You have the right to an attorney. As I said, you also have the right to represent yourself. If you choose to represent yourself, I just want to advise you that you would be at a serious disadvantage. As a prosecutor, as I tried to explain earlier, is a trained attorney, been through law school, been practicing law for a while, well-trained, well-versed in the rules of evidence, well-trained, well-versed in the rules of criminal procedure, been through jury trials before, they know how to conduct them. And so if you were to represent...
I object to everything. That line says it all. When objections lose meaning, so does defense. At this point, the process keeps moving whether the defendant understands it or not.
It has nothing to do with the facts. That's why I'm the trustee. It has it has everything to do with the trust law. The trustee of the person is here, and the beneficiaries have already been named. That's why I have a trust, and my trust is private, and I don't see your trust. And in the trust that you have, the trust that the prosecutor has named you as the trustee. That's why you keep asking the prosecutor what they want to do, because they named you the trustee. And you guys brought me into court to bear gift, to give out gifts. And I'm not here to give out any gifts.
Right.
I'm here to object to giving out any gifts that's supposed to reduce the public debt. Am I wrong?
Yes. Yes, you.
And that's how a case moves to trial without ever resolving the core misunderstanding. The court stays grounded in law. The defendant stays locked in theory.
You are. And that's frankly, that's kind of the sad thing, because I'm really not sure completely of what you're saying, but a lot of the things you just said are quite simply not true. And I asked the prosecutor where they wanted to go in the case, because they file the cases, they choose to go forward. Sometimes, as you've seen today, if you've been paying attention, the prosecutor said, "No, Your Honor, we're going to dismiss this thing." And so I dismiss it. So I asked the prosecutor, they filed the case. What do you want to do with this case? They said they want to go forward, which brought about this conversation that we've been having. And that's just one example of one of the things you're wrong about in terms of this whole trustee thing. I don't know what that means to you, but I have an idea of what a trustee and is and things of that sort. And I don't have a trust. I'm not anybody's trustor or trustee. In this court, neither is the prosecutor. And so when you say, am I wrong? You know, the short answer to that is yeah. And unfortunately, and I'm taking some time to try and explain it to you, but I just don't feel like I'm breaking through. But to answer your question, am I wrong? Yes, you're wrong about a number of things, which is really unfortunate that I can't explain that to you or make that clear to you.
What's your evidence? Evidence is clarity.
I'm sorry?
What's your evidence that I'm wrong?
Well, I mean, you know, other than me just telling you that I'm not a trustee, I can't prove something doesn't exist. I mean, there is no trust. There's nothing else, and I have no documents that saying there's not one, and I don't have any document. There is no document saying that there is one. And so again, that's on that single issue. That's.
So you're not coming after my. So personal.
Again,
trust
I'm not sure.
Exist?
Well, let me rephrase. I'm not sure what that means. Again, you're charged with a crime. That crime needs to be resolved, or either through trial or resolution of some kind. And so, in terms of coming after your personal trust, and by the way, you know, I'm not the one who filed the charges. That was done by the prosecutor and all of that. And so, what they're trying to do, I think, and I don't know this for sure, and I'm just trying to do this by way of explanation, not because I'm on anyone's side. You know, it's their responsibility. They're bringing the charge. It's their responsibility to prove it beyond a reasonable doubt. It's your or the defense attorney's role to explain why the charge should never have been brought, or that there reasonable doubt exists as the charge was ever committed. That's what this is about. This whole trust thing, I think you're just going down a way that's really doesn't have any relevance to what's happening here. And I've tried to explain that to you, and I'm more than willing to continue. We can't go at it all afternoon, but I'm trying to make this as clear as I can to you. But again, it's unfortunate. It's a failing on my part that I'm not able to break through to you. Yes, we'll set it for status hearing. We'll set trial dates, and then we'll just go from there.
Your Honor, based on this conversation, the state has concerns about the defendant's competency.
Yeah, we're not going to go down that route right now. And so you can raise that, but I'm not denying that without prejudice. But at this time, we're not. For one thing, as you well know, given the nature of the charges and given the schedule, this case will drag everything on we'll be here for the next couple of years. And at this point, I'm not prepared to do that. So you can bring this up again if you wish, but for right now, we're not going to go there. And do you understand what the state just said to me and what I turned them down for? Again, that's a yes or no question. The representative from the state, the prosecutor, she just said something to me. And I said, no, we're not doing that now. She made a request of me. And so do you know what that request was?
I am the trustee, and the beneficiaries have been already named. So,
all right. Has he been sent discovery?
No, Your Honor.
Okay.
Because
Yeah, I understand why. I understand why. All right, so what's 3 weeks? What's 3 weeks from today?
If you think confidence alone wins cases, this is your reality check. If this breakdown helped you understand how these situations spiral, hit like, subscribe, and we'll see you in the next one.